Good day. This is Professor Michelle Kelly Lowe. I am one of your lecturers for Banking Law 2. In today's online lecture, I will be covering certain aspects of Topic 2.3, Letters of Credit, and Topic 4, Demand Guarantees. The purpose of online discussions is to merely guide you through certain parts of the module. It is by no means a comprehensive discussion of all the material you need to study. With the online discussions, we focus on making it easier for you to study and work through the different topics. It is ultimately still your responsibility to master each topic. Please constantly check MyUnisa for additional material that may be prescribed during the year. I will be conducting this online discussion of the topics mentioned in two parts. In part 1, I will cover general principles. In part 2, I will cover exceptions to the autonomy principle. More on that later. Now, demand guarantees, commercial letters of credit, and standby letters of credit have become an established part of a local and international trade, particularly in construction and engineering contracts and international sale of goods contracts. Now, the instruments demand guarantee, commercial letter of credit, and standby letters of credit are sometimes jointly referred to as documentary credits. Sometimes the word documentary credit is just referred to as letters of credit, but most generally it's referred to all three instruments mentioned. A little bit of background to demand guarantees, how they exist, why are they in effect, and how did they develop? Now, a person planning to enter into a contract for the purpose, for example, of purchasing goods or the construction of works may be concerned to conclude a contract with a counterparty if there has been no dealings before, and they may wish to have some security for the counterparty's performance of his obligations, especially if there's been no dealings before. Now, in the past, it was common practice in international and local transactions to require the furnishing of a cash deposit to serve as a form of security that the counterparty would indeed perform the undertaking obligation. Now, later when international trade expanded this practice of furnishing cash deposits, it became prohibitively expensive for the counterparty to supply these big cash deposits. It was very difficult, for example, for sellers, exporters, suppliers, and contractors to survive the strain on their cash flow if they had to rely on their own resources to furnish the cash deposit, and therefore the assistance of financial institutions became essential in this part. Now, in due course, this practice was replaced with a safer and more convenient practice, namely the provision of a written undertaking by a bank in favor of the buyer or employer, and it was usually payable on demand. Now, the purpose of that cash deposit was really that the person, the counterparty, could hold that security, that cash, and if the other party to the contract, for example, construction or the purchase sale of goods, defaulted or did not supply the goods, the person in possession of this cash could simply take the cash, keep that, and use that to either get a new contractor in to complete the construction work or to purchase new goods from another supplier. Now, as I mentioned today, these payment undertakings are known as demand guarantees, and that has replaced this cash deposits. Now, demand guarantees are known by various names. Sometimes it's referred to as an independent undertaking, a performance bond or guarantee, a construction bond or guarantee, a tender bond or guarantee, independent bank guarantee, a first demand guarantee, a bank guarantee, or a default undertaking even. Now, it is also commonly known as a standby letter of credit. Now, a standby letter of credit is in essence the same type of instrument as the demand guarantee. The standby letter of credit has a very different historical development than the demand guarantee. Standby letters of credit were developed by banks in the United States as an extension of the idea of the traditional commercial letter of credit that has been used in international sales contracts. Now, USA banks developed the use of standby letters of credit as a result of legislation that initially prevented the US banks from giving guarantees as part of their banking businesses. Now, US banks were initially not permitted to issue guarantees. Therefore, they adopted the term standby letter of credit to avoid the language of guarantees. Today, USA banks are permitted to issue demand guarantees. The practice of standby letters of credit have also developed and is used worldwide, including in South Africa. Now, what is a demand guarantee? A demand guarantee is usually a very concise or a simple instrument issued by a bank or another financial institution or even an insurance company, under which the obligation to pay a beneficiary a fixed or maximum sum of money merely arises upon the making of a demand for payment in the prescribed form and sometimes also the presentation of documents as stipulated in the guarantee within the period of validity of the guarantee. Now, a demand guarantee is often payable on first demand, in other words, by a paper-based document, and this reflects the origin of replacing the cash deposit. Now, guarantees are often written in a manner where it requires at least a statement indicating that the principal is in breach. In other words, one part contract party to the underlying contract, which could be your sale of goods or a construction contract, for instance. Now, like the substitute for cash, it must be honored on the presentation of a written demand that complies with the provisions of the guarantee. In other words, whatever document the demand guarantee in the document itself call for must be submitted to claimed payment in terms of the demand guarantee. Now, it's common practice for many buyers, in particularly foreign buyers, to demand that sellers, exporters or suppliers provide a demand guarantee as security to ensure that the terms of their tender or a contract, of course depending on the circumstances, are adhered to. As mentioned before, they form an integral part of international trade and international sale of goods. Now, typically, in a demand guarantee structure and the parties involved, there should be at least a minimum of 3 parties involved in the provision of a demand guarantee. When there are 3 parties involved, we usually refer to that as a 3-party demand guarantee or a direct demand guarantee. Now, the first party, or as I mentioned, there should be at least 3 parties. The first party is either the principal or the applicant. Now, that would be typically the party to the underlying contract. For example, your seller, your exporter, your supplier, or the contractor whose performance is required to be covered by the demand guarantee. And that is the person who gives instruction for its issue. He is commonly referred to as the principal, the applicant, and sometimes even the account party. Now, the second party that is required would, of course, be the other party to the underlying contract. And that is the person that will be the beneficiary of the demand guarantee. In other words, the person in whose favor the demand guarantee is issued. The third essential party would be your guarantor, which would be insurance company or bank that issued the demand guarantee on behalf of your principal and is normally its customer. Now, if we look at this example on the slide, you would have a principal contractor, say in South Africa, wanting to conclude a contract with the beneficiary or the employer in Australia for, say, the building of a big construction site. So they conclude a contract on the underlying contract being the construction contract. But Australian company is uncomfortable with contracting with a South African company where they've had no dealings. He would then insist that a bank in South Africa issues a demand guarantee in its favor on behalf of the principal, the main contractor in South Africa. So in this scenario, it would be a direct three-party demand guarantee. But you can also get other parties, for example, where there are four parties involved in a structure. That we will refer to as an indirect or a four-party demand guarantee. So in our same scenario, what we have, same scenario, company South Africa concluding a contract with the employer in Australia. But the scenario is different where the company in Australia insists that it's not a bank in South Africa that issues the demand guarantee, but rather a bank in Australia that he knows and trusts. And in this scenario, what will happen is the principal, the contract in South Africa, will contact his bank in South Africa, instructing it to please issue a demand guarantee by a bank in Australia. Now, the principal's bank in South Africa will then become the instructing party, instructing a bank in Australia to issue the guarantee on its behalf, and the bank in South Africa will issue a counter guarantee to make good on the loss should the demand be made on the Australian bank in Australia. So the Australian bank in this scenario would be the guarantor, and the bank in South Africa would be the instructing party. So in this scenario, there would actually be two demand guarantees. The main one guaranteeing the underlying construction contract there, and then there will also be the counter guarantee, which the South African bank has issued in favor of the Australian bank should there be a demand. Now, when dealing with demand guarantees, it's very important to look at the characteristics of demand guarantees. Now, a demand guarantee, the biggest example, the biggest benefit of this is that it's a speedy monetary remedy against the counterparty to the underlying contract. And to that end, they are primary in form and documentary in nature. Now, what that means is the demand guarantee is a primary payment undertaking. It's abstract. What that means, it's not like a suretyship where you need to prove default. With a demand guarantee, it serves as a security that will make good to the beneficiary should there be a default. But with a provider that you do not have to prove that there's been actual default by the underlying contract, the party to the underlying contract. And it also means that it is documentary in character. Now that means that it is solely payable on demand by presenting the documents as per set out in the demand guarantee itself, just as long as they conform to the terms of the undertaking. And it also means that the demand guarantee is totally independent of the underlying contract. Now, the underlying contract could be the contract for the sale of goods or the construction contract. And as I mentioned, you do not need to prove default, actual default. If the documents called for in the demand guarantee simply provides that it is a demand can be made once a demand in writing has been made that the counterparty has defaulted, once you present that document, the guarantor will have to pay on that, despite there not being actual demand, a default by the principal that organized the issuing of the demand guarantee. Now, any demand within the maximum amount stipulated in the demand guarantee must thus, in principle, be paid by the guarantor, for example, the bank or insurance company, irrespective of whether the underlying contract, example, the construction contract, has in fact been breached or whether there's been actual loss suffered by the beneficiary, in other words, the other party to the underlying contract. Now, as I mentioned, this is in strong contrast to the suretyship guarantee. A suretyship guarantee is an undertaking to be answerable for another person's debt or default, and that is triggered only by proof of actual default and is not independent of the underlying contract, and which is limited to the amount of loss suffered from the default within the maximum amount stipulated in the guarantee. Now, there are different types of demand guarantees that can be issued. A demand guarantee are usually issued for a certain specific performance in an agreement, in an underlying contract. For example, you could guarantee that the counterparty would perform in terms of the guarantee, or it could guarantee that someone that receives a tender will in fact deliver the contract and sign the contract once he gets the tender. It could even guarantee after the construction contract, and there are defaults on the building. It could include the maintenance guarantee, where the contractor can hold that money for any defects that they need to remedy afterwards. So there are different types, and in the prescribed material, we do deal with the different types of demand guarantees. Technically, demand guarantees can really guarantee any type of performance or non-performance. And you also get different types of standby letters of credit. Now, demand guarantees can be revocable or irrevocable. Now, although surety companies, insurance companies, banks, or other financial institutions all may issue demand guarantees, they are most often issued by banks. Now, as I mentioned, we can distinguish between irrevocable and revocable demand guarantees. But in practice, demand guarantees are invariably irrevocable. Now, irrevocable demand guarantee constitutes a definite undertaking of the bank to pay the beneficiary or another bank, depending on the circumstances, provided that the stipulated documents in the instrument, if any, are presented to the bank and that the terms and conditions of the instruments are complied with. It gives the beneficiary a high degree of assurance that he will be paid, provided he complies with the terms of the guarantee. An irrevocable demand guarantee cannot be amended or cancelled without the consent of the beneficiary or other bank, of course, depending on the circumstances. Now, when the bank issues a revocable demand guarantee, the bank gives notice to the beneficiary or another bank that it can be amended or cancelled at any moment, and even without any prior notice to the beneficiary until the demand has been honored by the bank. So the revocable demand guarantee is not a good form of security, as the bank can withdraw that guarantee at any point. Standby letters of credit as well as commercial letters of credit may all be issued irrevocably or revocable. Now, letters of credit. Now, the commercial letter of credit was first employed by merchants to effect payment and to finance their transactions in the early part of the 19th century. So a completely different development to demand guarantees. It's more payment instruments, and they were used at the earliest in the 19th century. Now, since then, the law of letters of credit have developed mainly through practice and customary usage. One can also distinguish between irrevocable and revocable letters of credit, as mentioned. Now, in international trade, commercial law letters of credit have long been commonly used as instruments to secure payment. Now, the letters of credit secure the claim of the seller to obtain payment of the price. The essence of every letter of credit is an independent promise or independent undertaking by a bank or any other issuer of such a letter to pay the purchase price to the exporter against the presentation of precisely described documents, such as a bill of lading, a commercial invoice, or any other document representing the goods sold. So you can see that is totally different to a demand guarantee, where the document could be as simple as a little letter claiming payment or mentioning that there's been a default, and you presented that to the guarantor, and if it complies with what the demand guarantee stipulates, payment should be made. But with letters of credit, it's precisely exact documents that need to be presented as called for in the letter of credit, and it serves as a form of payment for the goods purchased, for example. Now, how does the operation of a letter of credit work? Now, a traditional contract of international or domestic sale will normally stipulate that payment for the goods are to be made by means of a commercial letter of credit to be procured by the buyer. Now, in such a transaction, the buyer of the goods normally causes its bank, which we call the issuer, to issue the letter of credit in favor of the seller of the goods. Now, the buyer will thus apply for the credit, and he is referred to as the applicant. Now, the seller is the party to whom the credit runs. That is the beneficiary of the letter of credit. Commonly, the issuer causes the bank in the seller's market, in his own country, for example, the nominated bank, to advise the credit, the advising bank, in other words. Now, often the advisor or the advising bank will also confirm the credit, then we refer to it as the confirming bank, or at least pay it under the issuer's mandate, in other words, the mandate of the paying bank. And then the issuing of the letter of credit does generally involve a large number of parties. Now, the nature of demand guarantees, standby letters of credit, and commercial letters of credit are all the same. In essence, they share similar characteristics. Now, standby letters of credit, demand guarantees, and commercial letters of credit are all treated as autonomous or independent undertakings whose operation will not be interfered by the courts on grounds immaterial to the guarantee or credit itself. In other words, it stands separate from the underlying contract, whether that was a sales contract or a construction contract. And we refer to this principle, the principle of autonomy or independence principle, or we can call it the doctrine of autonomy. In other words, payment is not dependent on any default or non-default in terms of the underlying contract, and they stand separately. The rights arrive only from the demand guarantee or the standby letters in that instrument itself. The other important characteristic or fundamental principle of demand guarantees and letters of credit is that these letters of credit transaction or demand guarantee transaction is that if the documents, where they are applicable, are presented and they are conform or are in line with the terms of the credit or the guarantee, the issuer or the guarantor, the bank, for example, or insurance company, has to pay, and if the documents do not correspond to the requirements, it must not pay. So, in essence, if we compare the demand guarantee to commercial letters of credit, there are similarities between them, but there are also important differences. Demand guarantees provide protection against non-payment or late or defective performance. So it's a form of security, and it's payable only if there's a default. But remember, the default does not need to be proven. It can just be alleged. And payment in terms of demand guarantees will therefore not always take place. It's a form of security. It's only if there's a demand that payment will take place, and if the demand is made in the proper and compliant form as called for in the demand guarantee itself. Whereas letters of credit is a method of payment. There will be a claim on a letter of credit. It provides the security for the exporter, for example, or a seller against non-payment. So you use a letter of credit as a method of payment. That is how you pay for the goods or services. Whereas the demand guarantee, not necessarily that payment will be made. Now, if we look at the demand guarantee, what is the key elements of it? What is in a contract or an instrument, a demand guarantee in that specific contract? Now, usually in a demand guarantee, you will list the two parties involved to the underlying contracts. It will usually include a reference to the underlying contract. So the reason why the demand guarantee came about. But it will not say that it's subject to it. It will just have a reference to this demand guarantee is issued for the performance of this construction guarantee concluded between party A and party B. It will include an amount or a maximum amount of the guarantee that may be claimed. It could include the currency of the payment, and then importantly, it will include the documents, if any, to be presented for the purpose of a demand. That is where you call for a demand needs to be in writing, or that you can say that the demand would require the party to state that there has been a default, or that the contract party was sequestrated and that is why you're claiming, for example, whatever the instrument calls for. It will have expiry date or expiry provisions, It will include maybe provisions for any extension and the date of issue. Now, most countries, both of common and civil law origins, there are no explicit statutory rules for demand guarantees or standby letters of credit or commercial letters of credit. Now, any disputes based on these instruments are usually addressed under explicit contractual provisions, if there are any, unwritten rules, the principles of contract of the law applicable, and commercial law, case law, and even legal writings. Now, many countries have no governing legislation. South Africa and the United Kingdom, England, are countries that do not have specific legislation dealing with these instruments. Now, the United States of America has a comprehensive legislation, and that is found in Uniform Commercial Code Article 5, dealing with letters of credit and demand guarantees. There are, however, international rules that are available to parties should they choose to include these international rules into their instruments. Now, the International Chamber of Commerce was founded in 1919, and they conclude these rules for election by parties to include into the instruments. It consists of many countries. Now, the most relevant instruments they have available, should parties decide to include, that is the ICC, Uniform Rules for Contract Guarantees, the Uniform Rules for Demand Guarantees, or the acronym URDG. They've got a version 1992 and 2010 version. There's also the International Standby Practice, which was endorsed by the ICC. Now, those three rules, mainly apply to demand guarantees and standby letters of credit. But the ICC has also got Uniform Customs and Practice for Documentary Credits, various versions of that. The previous version is the UCP 500, the acronym, and the current version we have is UCP 600. Now, the UCP 600 mostly apply to commercial letters of credit, but they can also apply to standby letters of credit and also by implication also to demand guarantees. Now, these instruments of the ICC, as mentioned, are available as international standard term contract rules available for incorporation into these instruments by the parties if they so choose. A very important instrument is also the United Nations Commission UNCITRAL Convention. They concluded the United Nations Convention on Independent Guarantees and Standby Letters of Credit in 1996. In that instrument, convention, they used the term independent undertakings. Now, the UNCITRAL Convention could only come into effect after it had been ratified by 5 states. Furthermore, in terms of Article 28, it could only enter into force at the first day of the month following the expiration of 1 year from the deposit of the 5th instrument of ratification. As a result, the convention only came into effect on 1 January 2000. Now, once a state accepts the convention, it becomes law in that state. Now, since the adoption of the convention, no major trading nation has acceded to it yet. Although the ICC has endorsed it and the World Bank has accepted it and has approved it. Now, the United States has signed it but not accepted it yet. Apparently, they have plans to do so. So, should a country conclude a contract with a demand guarantee or standby letter of credit with Ecuador, El Salvador, Kuwait, Panama, Belarus, Tunisia, Gabon, and Liberia, then the convention would apply to that instrument unless it was specifically excluded by the parties. Now, South Africa has not signed or acceded to it yet, and so far they do not have any immediate plans to do so. Now, when we deal with demand guarantees, as I said, a major issue is that it's different from suretyship agreements or accessory undertakings. Remember, with suretyship guarantees, default of the principal debtor needs to be proved to be able to claim. With demand guarantees, you do not need to prove actual default. Now, the important cases that we have prescribed where this became an issue, where the courts had to decide whether the instrument was a primary undertaking, a demand guarantee, or whether it was an accessory undertaking, obviously leading to different consequences. Now, the first important case is the Minister of Transport and Public Works versus Zandvoort Construction. Now, in this case, it involved two construction guarantees. This case is very important as it illustrates that it's not the name or a label, or for example, the title or a heading that is given to a payment obligation or undertaking that determines whether or not it is accessory or independent in nature, but rather its substance and the construction that does. So how we interpret that. In this case, the Western Cape Department of Transport and Public Works concluded two construction contracts with Zandvoort Construction for the building of two pathology laboratories at two different hospitals in South Africa. Both construction contracts called for construction guarantees. So in this instance, the underlying contract was construction contracts. Now, the construction guarantees were both issued by Absa Bank. Now, it was very relevant to this case, and the outcome of this appeal court case was the interpretation of the two construction guarantees or demand guarantees. So this was a specific type of demand guarantee, a construction guarantee. They were identical in their terms and nature. The construction guarantees contained various important clauses that the court had to construe to determine the nature. Now, they both contained the following relevant term. It read, the bank reserves the right to withdraw the guarantee after the employer, that is the department, has been given 30 days notice, written notice of its intention to do so, provided the employer shall have the right to recover from the bank the amount owing and due to the employer by the contractor on the date the notice period expires. It also contained other important provisions. It stipulated in the construction contract, the underlying contract in other words, that the contractor Zandvoort shall provide the employer, the department, with a bank guarantee of 10% of the contract value as security for the compliance of the contractor's performance of obligations in accordance with the contract. And whereas the bank, Absa Bank, is willing to agree to the guarantee an amount which is equal to 10% of the contract value under certain conditions stipulated thereunder. The importance part as security for the compliance of the contractor's performance. Another important provision was now therefore we the undersigned, in other words the bank, the guarantor, in our capacity as employees of the bank do hereby guarantee and bind the bank as guarantor for the due and faithful performance by the contractor of all its obligations in terms of the said contract subject to the following conditions. So from that we can see the bank guarantees and binds itself for the due and faithful performance of all its obligations. So not only monetary, but all the obligations. Other provisions include, with each payment under this guarantee, the bank's obligation shall reduce pro rata. Each claim by the employer, in other words the department, must be made in writing and accompanied by a signed statement that the contractor has failed to fulfill its obligations in terms of the contract and shall be sent to the bank's domicilium address as indicated. So to make a demand in terms of this case, the beneficiary simply had to make a signed statement that the contractor had failed to fulfill its obligations in terms of the contract. So it's called for a written demand stating that there had been that the contractor did not fulfill its obligations. Now, for a full discussion of the case, you can look at this prescribed discussion. Now, if we look at the Zandvoort case and the provisions I've just gone through, the Supreme Court of Appeal was of the opinion that the aforementioned terms quoted above was in line with language you would usually find in suretyships and not independent demand guarantees. So in addition, the court was also of the opinion that the term in the guarantees reserving the right of Absa Bank to withdraw from the guarantees after 30 days notice which the bank did invoke in this case, referred to in the previous slide, particularly limited the liability of the bank to the amount owing by the contractor under the underlying contractor. This was obviously an indication of a liability similar to that of a suretyship. Clearly, this was not the intention with the instrument, but that is what happened in the way it was drafted. Now, a big focus of some of the South African cases in the last couple of years have been instances where the court had to construe, had to interpret certain guarantees or words or phrases or terms used in them. And the Supreme Court of Appeal had to construe a guarantee to determine whether or not the instrument before it considered a primary guarantee or an accessory guarantee. Another important case where this came about, where it was interpreted, was the mutual and federal case we'll get to in a minute. Now, when courts are asked to interpret instruments, whether they are a suretyship agreement or whether they are independent instruments or payment obligations like demand guarantees, they will use the normal rules for construing or interpreting contracts. Now, the general rule in South Africa of construing the common intention of the party is firstly to consider the language used in the contract. Generally, interpretation involves a four-step technique. Courts will first look at the ordinary grammatical meaning of words in the contract. Then they will give attention to the context in which the words or phrases are used as measured against the contract as a whole. Thirdly, they will only look at background circumstances to determine the purpose of the contract. And lastly, they will also take cognizance of the surrounding circumstances. For example, the language in the contract is in, where the contract, for example, is ambiguous, the language. So generally, they will look at the general meaning. When there's ambiguity, they will look at the background surrounding circumstances or the factual matrix as it's referred to. So nonetheless, the ordinary grammatical meaning, they will not easily ignore that. So it's important when contracts are drafted to use very simple language. Now, South African courts use this modern method, the matrix of facts, very similar to the English courts in interpreting these contracts when there is, specifically when there's ambiguity in the instrument itself. Now, English courts have taken this approach of relevant surrounding circumstances, and they have a very important case where South Africa follows them, and it's the Rainy Sky case, where the English Supreme Court basically said if there's two possible interpretations of a commercial instrument, like a demand guarantee, and the one will lead to where it's absurdity, a business absurdity, they will rather prefer the common sense one that makes business sense and substitute that as the interpretation of instrument. And that is what South Africa did in the Zandvoort case as well as in the mutual and federal case. So we follow a very similar approach. Now the danger with that is, of course, that the court, when they interpret something that has been ambiguously drafted, they will now substitute that with their own judgment of what makes business sense. What is the more reasonable sense of business? So there's a big danger in that, and that is why it's important that a document is drafted in plain, simple language with the clear intention that it's a primary payment obligation and not accessory payment obligation like a suretyship, if that is the intention of the contracting parties. Now, the mutual and federal case is also a Supreme Court of Appeal case, a very important case, as it also deals with a matter where the court had to interpret whether the instrument was a demand guarantee or a suretyship. Now, this case involved the South African National Roads Agency, and they concluded a contract for the construction of roadworks in KwaZulu-Natal with K&S Construction. Now, K&S Construction in turn appointed a subcontractor, Aqua Transport and Plant Hire, for the construction works. Now, in terms of the subcontractor was required to provide a performance guarantee to the value of 15% of the main contract. The guarantee was not to have an expiry date. Mutual and Federal Insurance Company issued the guarantee on behalf of the subcontractor, the applicant of the guarantee, for the due fulfillment of the subcontract's obligation to the beneficiary pursuant to the subcontract entered into between Aqua Transport and KNS Construction. Now, KNS Construction is the beneficiary of the guarantee. It instituted an application in the South African Gauteng Local Division demanding payment from the guarantor, mutual and federal, based on the guarantee. Now, the beneficiary claimed payment on the ground that the guarantee was an independent primary guarantee and was therefore payable. Now, the subcontractor, Aqua Transport, the applicant of the guarantee, disagreed and contended that the guarantee was in reality an accessory guarantee akin to a suretyship. Now, the guarantee contained the following clauses. Mutual and federal do hereby hold at your disposal the amount of around 3 million for the due fulfillment of Aqua Transport of its obligations to KNS Construction in terms of the above stated contract between subcontractor and KNS. The guarantor hereby renounces the benefits of the exception non numerate, pecunia, non causa, debiti, exclusion, and division. The meaning and effect thereof we declare ourselves to be fully conversant. Another provision provided that the guarantor undertakes to pay KNS the said amount of around 3 million or such portion as may be demanded on receipt of a written demand from KNS, which demand may be made by KNS if the said contractor fails or neglects to commence the work as prescribed in the contract, or if he fails and or neglects to proceed therewith, or if, for any reason, he fails and neglects to complete the services in accordance with the conditions of contract, or if he fails or neglects to refund to KNS any amount found to be due and payable to KNS, or if his estate is sequestrated, or if he surrenders his estate in terms of the insolvency law enforced within the Republic of South Africa. Now, by looking at these provisions, the court had to interpret whether this was a suretyship or whether it was a primary guarantee. Now, if we look at clause 2 there, for example, the renunciation of these benefits is something you usually find in a suretyship agreement. And the court also agreed that that was sort of problematic. Now, in the mutual and federal case, the Supreme Court of Appeal held that the language used in the construction guarantee constituted an accessory liability, akin to a suretyship. And it held that the guarantor was therefore obliged to pay if demand made in terms thereof complied with terms of the guarantee. The Court of First Instance disagreed, but the Supreme Court of Appeal felt that it was a suretyship, and therefore the appeal was successfully upheld as it was found to be an accessory liability. In other words, actual default needed to be proven as well. Now, courts will only interpret a guarantee as constituting a primary undertaking where such an intention is clear on a proper interpretation of the guarantee as a whole. So any ambiguity in the clauses of the guarantee may lead to a conclusion that the intention was to create an accessory guarantee. So the language of the guarantee is decisive. Any uncertainty regarding the exact payment obligation, and the court will likely conclude that it is an accessory in nature akin to a suretyship. So the best construction of demand guarantees is to really keep it simple and clear, and to clearly state that it creates an independent primary guarantee and with no means of creating an accessory guarantee. For example, in the First Rand Bank versus Barrera Investments, that payment guarantee, in other words, demand guarantee, simply provided that any reference to the underlying contract in the guarantee was merely for the purpose of convenience and should not be construed as any intention whatsoever to create a suretyship. Now, that is a very good clause to include in a demand guarantee, as it removes any doubt as to what the nature of the payment obligation is. Now, lawyers tend to use legal jargon and fancy language, and they tend to lose sight that this instrument preferably should be a short and concise instrument. And they tend to elaborate, and that might end up causing confusion as to what the true nature of a demand guarantee or instrument is. Now back to one of the fundamental principles underlying demand guarantees, letters of credit, and commercial letters of credit is the documentary compliance, the documentary nature. As I said, payment is claimed on all these instruments by submitting a document to claim as set out or stipulated in the instrument itself within the validity period. Now, but when it comes to this documentary nature of these instruments, a problem arises as to how strictly the documents or the demand, whatever the instruments call for, needs to be conformed to comply. And the question arises, is it a very strict standard so that even the most minor deviations entitle the guarantor, the issuer, for example, the bank or insurance company, to refuse payment and indeed oblige it to do so, otherwise authorized by the principle of the guarantee? And that we call the doctrine of strict compliance. So is it a strict standard, crossing the T's, dotting the I's? What is meant with that strictness? Or the other question is, or is substantial compliance sufficient? And can small things be ignored when documents are submitted? And that is the main problem and question. And again, this boils down to construing these instruments, what they call for, and then construing whether the documents that were submitted, whether they do indeed comply with what is called for. Now, when you have a document, the important thing to determine whether the document or the demand comply is to first determine whether there are any legislation or non-legislation that applies to the instrument. For example, what law applies. In South Africa, we have no legislation. The UK, no legislation. However, if the instrument was subject or issued subject to these international rules by the ICC, for example, the ISP 98 or URDG, or in the letters of credit, for example, UCP, or if the UNCITRAL Convention applies, that will be important. Those rules and the convention all supply or put out certain requirements and certain provisions when it will be deemed that certain documents comply or do not comply. And then, due to the international nature of these instruments, courts will usually look at the position not only in the local country, but also how other jurisdictions deal with this. South Africa often looks at English law and English decisions on this, as well as American law. Sometimes they even refer to Australian law and look for guidance on how to apply these principles in South Africa. So another big focus of South African cases have been on the construing the terms and clauses of demand guarantees to determine whether or not the documents presented by the respective beneficiaries complied with the terms of the guarantee. Thus, they had to deal with arguments as to whether or not the doctrine of strict compliance also applies to demand guarantees. Now, in South Africa, it's generally accepted that the doctrine of strict compliance applies to letters of credit. That does not necessarily mean that every I and every T needs to be crossed, but there needs to be strict compliance with what is a clear typo might be excused. But in essence, one would have to look at what the instrument calls for, but it is strictly. It can't be substantial. And that is the position for letters of credit. Now, when it comes to the issue of letters of demand guarantees, the situation is less clear. A very important case was Compass, where the case was concerned with whether or not the beneficiary had complied with the requirements of the demand guarantee given by the guarantor when it made its demand for payment. Now, in this case, Hospitality Developments was a property developer, and they had been contracted to carry out the upgrade of a hotel. It appointed a construction company for this purpose, which in turn contracted with a subcontractor to install a computer network wireless system in the hotel. The work of the subcontractor was backed by a construction guarantee, issued by Compass Insurance, the guarantor, so it was an insurance company, a short-term insurer, and they had issued the demand guarantee in favor of Hospitality Hotel Developments. Now, the case was concerned with whether or not the beneficiary had complied with the requirements of the demand guarantee given by the guarantor when it made its demand for payment. In Compass, a copy of the liquidation order had to be attached to the demand, but it was not, and it was only supplied months later after the guarantee had already expired. So the question was whether there had been compliance. Now, in this case, it was argued that a less strict doctrine of compliance applied to demand guarantees, and they used English law as authority. Now, unfortunately, the Supreme Court of Appeal did not, because of the facts where they ruled that in this instance it was not a matter of whether there was strict compliance or not. In this case, there was no compliance because the copy of the liquidation which was called for was not submitted when the demand was made. So one could not argue strict compliance when there was no compliance. So the question was left open. Now, another important case where the same argument came about, relying on English law, that a less strict doctrine of compliance applied to demand guarantees, arose in the State Bank of India versus Denel case. Now, the Court of First Instance referred to an opinion that the principle of strict compliance should also apply to demand guarantees, but unfortunately, they did not address this. It was also not addressed by the Supreme Court of Appeal. Now, in this, so if we look at the Compass, that is just the slide to give you a little bit of a bird's eye view of the facts of that case. Now, the State Bank of India, it was one of the infamous, well-known cases where it was the arms, one of the arms deals, the selling of Denel from ammunition and defense equipment. Now, Denel, the South African SOE, and a manufacturer and supplier of defense equipment, entered into a contract with the Union of India, the government of India, for the supply of defense equipment and ammunition. That was the underlying contract. Now, the sales contract contained warranty clauses concerning the goods sold and clauses concerning Denel's performance in terms of the contract. Now, the Union of India required Denel to provide 1 performance and 7 warranty guarantees, in other words, 8 demand guarantees, in respect of the goods that Denel sold. Denel, through a South African bank, Absa Bank, requested 2 banks in India, the State Bank of India and the Bank of Baroda, to issue 1 performance and 7 warranty guarantees. And these were the principal demand guarantees issued in this case. They were subject to the laws of India. Now, these guarantees that Absa Bank requested the banks in India to issue were secured by 8 counter guarantees issued by the South African bank, Absa Bank, and they were subject, 7 of them were subject to South African law and 1 was subject to the law of India. And they were silent as to any governing ICC rules. Now, during the course of a contractual relationship between the Union Bank, the Union of India and Denel, the Union of India alleged that Denel had breached its contract obligations and called upon the Indian banks to pay in terms of the principal guarantees, so the 8 main demand guarantees. Now, the Indian banks duly complied and in turn called on Absa to pay correspondingly amounts in terms of the counter guarantees, the security they had supplied for the banks of India when they issued these guarantees in favor of the Union of India. At first, Absa Bank refused to pay, contending that the demands were made in terms of the counter guarantees were not worded under and in terms of the main principal demand guarantees issued. Later on, Absa Bank changed its mind and advised Denel of its intent to make payment in respect of the counter guarantees. Denel disputed that Union of India was entitled to make demand on the principal demand guarantees and maintained that Absa Bank was accordingly not lawfully bound to honour based on the counter guarantees. Denel obtained an urgent interim interdict on an ex parte basis against Absa Bank, restraining the bank from making payment to the 2 Indian banks in respect of the counter guarantees that Absa Bank had issued pending the finalization of this application before the court. Now, the appellants in this case, the two Indian banks, the beneficiaries, in other words, of the counter guarantees, appealed against the interim interdict. The Supreme Court of Appeal of South Africa upheld their appeal in 7 of the 8 counter guarantees. In relation to one specific counter guarantee, the Supreme Court of Appeal set aside the interdict prohibiting the payment being made as it was subject to Indian law. Now, the main question that the Supreme Court of Appeal had to answer was whether Denel was entitled to an interdict prohibiting Absa Bank from paying out in terms of the 8 counter guarantees that the bank had issued in favor of the two Indian banks. Now, here again, it was argued in this case that a less strict standard of compliance was required in instances involving demand guarantees. Now, although the court of first instance referred to an opinion that said that the principle of strict compliance should also apply to demand guarantees, it unfortunately did not express its own view on the issue. It relied heavily on the Frans Maas English case to reach its decision. Now, unfortunately, on appeal, this important issue was not addressed by the Supreme Court of Appeal. The majority of academic opinions are, however, that the same doctrine of strict compliance, the same level of strictness applies to demand guarantees as applies to commercial letters of credit. Obviously, this matter has not been finally settled. Another case where the same issue arose of strictness, of doctrine of strictness as it applies to demand guarantees, arose in Christabel case. Now here, Credit Guarantee Insurance Corporation of Africa Limited had issued a construction guarantee in favor of Christabel Developments, who was the employer of the construction contract, the underlying contract. The guarantee was governed by South African law. The underlying contract was cancelled and Christabel made a demand on the construction guarantee. The construction guarantee called for a copy of the cancellation letter to be attached to the demand simultaneously, but the beneficiary, or Christabel, failed to attach it to the demand. The guarantor had received a copy of the cancellation letter and had acknowledged such a receipt a few days prior to the demand being made. So when the demand was made, the cancellation letter was not attached. It was sent prior. Now, Credit Guarantee Insurance Corporation argued that there had not been strict compliance with the terms of the construction guarantee by reason of the failure to attach the letter of cancellation to the letter of demand, and with such failure to comply with the preemptory provision of the guarantee, the demand was fatally defective. Christabel, in contrast, argued that strict compliance was not a requirement, that the letter of cancellation had been delivered prior to the letter of demand, which constituted compliance, and that in any case, Insurance Corporation had waived any entitlement to require Easterbell to attach the letter of cancellation to the letter of demand. Now, in this case, the court concluded that the prior presentation of a copy of the cancellation letter by Christabel to Insurance Corporation and the attorneys, instead of simultaneous presentation with the demand, based on the facts in this case, did not constitute compliance with the guarantee. Now, from this judgment, it would seem that the court applied a less strict doctrine of compliance when it construed the matter. Another case where a similar issue arose is the case of the University of the Western Cape versus Absa Insurance Company. Now, this case involved a demand made on a construction contract governed by South African law issued in terms of the underlying construction contract. The beneficiary of the construction guarantee, the University of the Western Cape, alleged that the contractor, third party to the underlying construction contract, had failed to perform in terms of the underlying contract, and therefore they had cancelled the contract. The university then proceeded to make a demand in terms of the construction guarantee. The guarantor, Absa Insurance, had issued the construction guarantee. Now, Clause 5 of the construction guarantee stipulated that subject to the guarantor's maximum liability, the guarantor undertakes to pay the employer the guaranteed amount upon receipt of a first written demand from the employer to the guarantor at the guarantor's physical address, calling on this construction guarantee, stating that the agreement had been cancelled due to the contractor's default, and that the construction guarantee is called up in terms of Clause 5, and that the demand shall enclose a copy of the notice of cancellation. Another important clause of the demand guarantee in this case was Clause 8, which provided that the payment had to be made within 7 calendar days upon receipt of the written demand. A note on the last page of the guarantee further provided that in the event of a call on this guarantee, payment will only be made against the return of this original guarantee by the employer or the employer's duly authorized agent. Now, the actual demand on the guarantee was not made by the university, but it was made by its principal agent on behalf of the university. It was also not made on the principal agent's letterhead. It was made on the principal agent's letterhead, and it was not on the university's letterhead. The demand contained a copy of the letter of cancellation of the underlying construction contract. Absa Bank refused to pay in terms of the guarantee, saying that there was no compliance with the demand. Now, the university sought judgment against Absa for payment of the construction guarantee. Absa resisted payment in terms of the guarantee on 2 grounds. Absa said that the university had failed to comply with the terms of the guarantee. It claimed that the demand had to be made by the university itself, and it also argued that the university's conduct in making the demand was tainted by impropriety. The guarantor argued that strict compliance, as in the case of letters of credit, was also applicable to construction guarantees. It insisted that the demand that was made did not constitute strict compliance with the letters of construction guarantee, as the demand was not made by the university but by its principal agent. Now, in this case, the court found that there was no requirement that the employer act personally in calling up the construction guarantee. The court's judgment seemed to imply that strict compliance with the terms of a construction demand guarantee is not required, and it took a very similar approach to the court in the Christabel case. Now, what are the reasons for this difference in standards of compliance between demand guarantees and commercial letters of credit? Now, there's been various arguments, and it basically boils down to the following. The one school that argues for a less strict doctrine of compliance for letters of credit, for demand guarantees, are saying that demand guarantees usually have less documents involved. It usually just requires either a written demand for payment or maybe a statement that the principal contractor has defaulted on the contract or was placed in liquidation. So it's not a lot of documents. And because it's only statements to the effect that something took place, a less strict doctrine of compliance is required. Whereas with letters of credit, especially commercial letters of credit, a large range of documents are usually required before payment can be effected. For example, the bill of lading or commercial invoice. And because of the nature of those instruments in letters of credit, the strictness is much heavier on the beneficiary of a letter of credit that there's strict compliance. So there are different opinions on that. Then there's also the school that states that it should be the same level of strictness. However, whatever the opinion or what the end of this will be, is what is clear is that the demand guarantee or the letter of credit determines the level of strictness required. If the instrument calls for a very strict level of compliance, that is what needs to be complied with. So again, back to construing and interpreting these instruments, and before you can determine whether a compliant demand was made, is to really look at your terms, what is required, and whether the documents that are presented do comply with what is called for. In your tutorial letter, various cases and articles and parts of books have been described to discuss this part and to study this. However, for those that are interested in further reading, although not prescribed, are welcome to look at the 2 articles on the screen. This then concludes part 1 of topic 2.3 and topic 4. In part 2, I will be discussing exceptions to the autonomy or independence principle in more detail. I thank you.